Hello and welcome back to the another episode of Indian Polity Lectures. Well, it is the sixth lecture today, and in this video, we are going to discuss various concepts related to fundamental rights. We are going to discuss it in a very detailed way. We'll discuss Article 12, Article 13, Article 14, and Article 15. So, this is what we are going to discuss today. Now, before we start our discussion, let me tell you about this initiative. Every day from 2nd June, we are uploading two videos on our YouTube channel. In the first one, we discuss the daily news analysis. We discuss the most important articles which are relevant for your preparation, whether it would be your mains exam or prelims exam. We try to discuss them in a detailed manner and we try to derive the possible prelims or mains questions from those particular articles so that it will give the idea how exactly you should prepare for the exam and how you can expect the questions from the current affairs part. And in the evening session, which is this evening or night session, we upload this video in which we discuss the static part. And we had promised you that whatever is needed for you to clear your exam, we will cover it here. And we started with Indian Polity. We are going to touch every subject. We are going to discuss every subject, what is important for your preparation except the optionals. We'll discuss everything here. And we started with the Indian Polity. So this is what we are going to do. And we aim that by the month of Jan 2026, we are going to complete your syllabus. So best of luck for us and best of luck for you. Please, if you are interested in our videos in this initiative, do subscribe the channel and hit the notification button so that you will get you will get the reminder that we had uploaded the video. Now, one more thing I would like to mention here, that as we are teaching you here, we are teaching right now, we are teaching Indian Polity. At the same time, we are making the notes of this subject. We are taking everything into our consideration, what is important for you, whether it would be related to prelims or mains. And at the same time, when we are making notes for every concept which we discuss there, we frame the questions related to prelims as well as mains, so that it will be the everything what you require to clear this subject. So if you are interested in getting the notes, they would be available once we will complete the once we will complete Indian Polity, or once we will complete this subject, the notes would be available. But you would have to pay for those notes. It would be just 200 rupees, which you will have to pay for each book. I would say each subject you would have to pay for that. You would have to pay 200 rupees for each subject. If you are interested in these notes, I can assure you that they will contain everything what is required for you to clear the exam. If you are interested, please do email us. We had given our email ID. You can email us and we will reach to you guys. Now, this is all about the initiative, what we are going to discuss here, what it is about, and about the notes. If you are interested, do subscribe us and do watch the video. Now, let's start with our discussion. First, let's try to recap what we discussed in our previous class. Try to recap that. In our previous class, we were left with few concepts related to citizenship. We discussed those concepts. We discussed the Citizenship Amendment Act, 2019. We saw why there were protests. We saw that what were the arguments in favor of that and what were the arguments in against that Amendment Act. After that, we discussed various other concepts also. We discussed the census, we discussed the delimitation in a very brief manner, because delimitation is not something which we want to discuss right now. When we will take up the parliament, there we will discuss that in detail. After that, we discussed various other concepts too, and then finally we started with the fundamental rights. If you can remember, in our last class we discussed Article 12 and Article 13. So here I will just give you the recap what we discussed. First, I will give the recap of these two articles, then we will move forward. First, we discussed the fundamental rights. So what is the fundamental right? Why it is called the fundamental right? Why it is called fundamental right? Because first, the reason first which should come to our mind, that it is given to us by the Constitution. by the constitution. It is protected by the constitution. Second, it limits the powers of the government. It restricts them. And if they are violated, and if the fundamental rights are violated, you can go to this Supreme Court. So because of these features, and also if we will see the nature of the fundamental rights, they enhance your personality, they enhance your, they give you the opportunities where you can enhance yourself. So because of the nature of the fundamental rights, they become the fundamental. First, it is protected by the constitution, it is given by the constitution. These are the highest rights which a civilian, which a citizen can enjoy. Third, under these rights, the constitution, it restricts the powers of the state. And also, if they are violated, you can directly go to the Supreme Court. Because of these features, it is called a fundamental right. After this, we also discussed the different rights. If we will see the hierarchy of the rights, we see that the rights are of two types. Usually rights are of two types. First, we saw that how rights which are given in the constitution, then the second, they are made by any statutory rights. We discussed that. In the constitution, we saw that especially those rights who are in part 3 of the constitution, part 3, and those who are outside part 3. What is the difference between these two rights? The major difference between these two rights is that if any right given in part 3 is violated, you can directly go to the Supreme Court. And for these which are outside the fundamental rights, for example, we have the right to have private property, right to have property. It is a constitutional right. It is outside the fundamental right. If it is violated, you will go to the lower courts first. You can go to the High Court, but not directly to the Supreme Court. This case may go on to the Supreme Court also, but first, where you will initiate it, it would not be initiated in the Supreme Court directly. It would be initiated in the lower courts. And also the protection to these fundamental right, to these other rights who are outside the fundamental rights, it is little lesser as compared to other rights, or as compared to part 3 rights. You would if you want to change anything with respect to part 3, you will have to check whether it is against the basic structure. Then you will need to bring in the Constitutional Amendment Act. Then only you can abridge it. Here, with respect to others, it is the headache would not be similar. There would be separate procedure. It is easier to it would be little easier to abridge these articles, these rights, as compared to the fundamental rights. Then we know that statutory rights, how they are ordinary rights, they might be legal rights. These are ordinary rights, and they don't enjoy the same protection as enjoyed by the constitutional rights. So this is the basic introduction of the fundamental rights. Then after discussing the basic introduction, we started with what? We started with we started with Article 12. What does Article 12 say? How Article 12, when we will read the fundamental rights, or when we will read the DPSPs, we will see that there is a common term used, that is state. State shall not do that. In DPSPs, state shall try to do that. We will often see that the word state is mentioned. So what is this state? That is defined by Article 12. And Article 12 clearly defines what this state is. First, what this state is. State includes, under Article 12, state, it includes what? It includes the Parliament of India, Government of India. Second, it includes the Government of India. Third, it includes the state legislature. Fourth, it includes the state government. Fifth, it includes the local authorities. And sixth, it includes other authorities too. Now, who are these other authorities? Who will decide whether it is a state? For example, if anybody is restricting your right, for example, if tomorrow BCCI decides that they will not, BCCI decides that they will not allow Virat Kohli to play for any reason, that he is performing well, but they decided that we will not allow Virat Kohli to play. So who will decide whether this BCCI it is a state or not. It is decided by whom? It is decided by the judiciary. It will be decided by the judiciary that whether it is a state or not. About BCCI, it is very much clear under the judgment that it is not a state, because it does not, even though it enjoys the monopoly, which we will discuss very soon, but it is not conferred to it by the state. So this is the judiciary which will decide. The point which I am trying to raise here, that which will decide these other authorities which are mentioned in Article 12. Who will decide who are these other authorities? It is the judiciary which will decide who are these other authorities. And what are the features of the other authorities? It is also described. Let's try to find out. Let's try to figure out what are these features. First, if there is authority which is funded by the government, funded by the state, which is defined under these 5 terms, then it is a state. Second, if there is a department and the employees employed there, it is or hired there or fired there or transferred there, it is done by the state, then it is a state. Then third point which I want to raise here, that if it functions as a government character, if it functions as a government character, then it is termed as a state. For example, the example which we discussed yesterday was Jal Board. After that, department of government has transferred any department to any corporate. Fourth, if the department of government, it has transferred any department to the corporate, then it would be the state also. And also any entity which enjoys the monopoly. Fifth, any entity which enjoys the monopoly. So what is this? Under this term, we discussed that how BCCI, even though it enjoys the monopoly with respect to the players who are going to play, they frame the team, but still they are not the state under the Article 12. Why? Because this monopoly, it should be conferred to them or protected to them by what? It should be conferred or protected to them by what? It should be conferred or protected to them by the state which is mentioned earlier. So it should be protected or conferred to them by the state. So this is what Article 12 is about. I hope you are very much aware of it now. If there is any confusion, I guess you had, if there was any confusion, I guess you had now cleared that confusion. Now let us see what question we discussed on the state on Article 12 yesterday. The question which we brought yesterday was consider the following statements regarding Article 12 of the Indian Constitution. First statement, Article 12 explicitly defines state to include the government and the Parliament of India and the government and the state legislatures of each of the states. 100% correct. Nothing wrong with the statement. Second statement, it also includes all local authorities within the territory of India or under the control of the government of India. 100% correct. Nothing wrong with it. Third, the Supreme Court has over time adopted a restrictive interpretation of other authorities, limiting them only to those bodies exercising sovereign government functions. It is totally incorrect, because we saw that how there are various functions. If any body is having that, to be given the status of state, and Supreme Court by its judgments we will understand that how it is not a very restrictive interpretation towards this, how Supreme Court has not given a very restrictive interpretation towards this article. So third statement is incorrect. Fourth statement, a private body, if performing a public function or acting as an instrumentality of the state, can be considered state under the expanded judicial interpretation of Article 12. 100% correct. So with respect to this question, what were the correct answers? Option 1, option 2 and option 3. Option 1, option 2, and option 4. So the correct answer would have been option C. So I hope by this discussion, what we discussed yesterday, in a way we are repeating it. You don't need to go to the yesterday's class to understand Article 12. We repeated it here. You would have understood what this article is about. So with this, let's come back to the first slide and take up the Article 13. Before we will take up the Article 13, now we are very much clear about Article 12 about the state. Let's try to find out what are the different rights given in the fundamental, what are the different rights, or what are the different protections given by the fundamental rights. About the fundamental rights, or about the right in itself, what do you mean by right? It is a claim which a citizen have. It is the claim, it is the authority, it is the claim given by the Constitution to the citizen that they can claim this thing. That is called the right. So let's try to understand what are the different rights given by the constitution, given by the constitution under fundamental rights. First, there is right to equality. Right to equality we have, which we will discuss under article 14 and 15, few parts of it under 14 and 15. Then we have the right to freedom of religion, right to freedom. First, right to freedom, this is also a fundamental right. Then third, we have right against exploitation, right against exploitation. Then we have religious freedom. It is also a fundamental right. Then we have the cultural and educational right. Then finally what we have the constitutional remedies, where we will understand different writs. This is what the fundamental rights contain. Earlier there used to be right to property, but it was taken away from the part 3, taken away from the fundamental rights. Earlier it used to be right to property was also the fundamental right. So this is what the fundamental rights contain. Now coming back to our discussion, let's start with article 13. What article 13 is about, let's try to find it out. Let me rub it first. Article 13 is very easy to understand. For example, before we got independence, were there any laws which were governing us? 100% there were laws which were governing. For example, the biggest example is of the IPC. It was there. After independence, when we enacted our constitution, when the constitution came in, we had the fundamental rights. What will happen to the IPC? What will happen to the IPC? Will it stand, or will it be termed as null and void? So what will be the status of IPC? That is defined by Article 13. What does the Article 13 say? Article 13 says, if any law, Article 13 says, if any law which is against or is opposite, we can say, if any law which does not stand with the constitution, or which does not stand with the fundamental rights, will be termed as void. Any law which does not stand with the constitution will be termed as void. Now here is the discussion, here is the point. For example, in IPC there are different sections which by the various judgments which were termed as they did not stood up with the constitution. Would they continue to exist? Would IPC on the whole, would it be termed as null and void, or any part of that which is against the constitution, that would be termed as null and void? And this principle, the principle of severability, or the principle of lapse, or the doctrine of lapse, or the principle of severability, it was discussed that, for example, principle doctrine of severability, it was discussed or doctrine of lapse. What does it say? For example, we gave the example of section 377 of IPC, section 377 of IPC, where it talked about the unnatural offense. So what is the unnatural offense? For example, if there is a sexual intercourse between man and man, for example, if it is not between penis and vagina, then it is an unnatural sexual offense, and and it is an unnatural, or we can say the bestiality, the sexual interaction between human being, man and a animal, or the incest, or the bestiality. These are very much unnatural, and if anyone is found under these, if anybody is found guilty under these crimes, he will be punished very severely. So this case went to the Supreme Court. There were questions with respect to the homosexuality. In the Naz Foundation, they went to the in 2001 Naz Foundation, they went to Delhi High Court. They said that, sir, in our country there are people who are suffering from HIV/AIDS, And who are these people? If you had understood about AIDS, it was basically this disease was majorly found in homosexual. In this disease was majorly found in those patients who had done homosexuality, especially the gay sex. This disease, this AIDS, it is majorly found in those patients. So this NAS Foundation, they went to the Delhi High Court and they said themselves, in our country there are many patients who are suffering from AIDS and we need to treat them. So Supreme Court told them, go and treat them. What is the issue with that? But here the NAS Foundation said, sir, they were the people who were involved in this, in the homosexual relationship. They were involved in the gay sex. And if we will start treating them, they will be held guilty under section 377 of the IPC, and they will be given the severe punishment. So what do you think? Delhi High Court acknowledged it, and Delhi High Court said that the section, you should go and treat them, and it said that the section 377 is unconstitutional. So my case here, why I'm discussing this, is because of this case, because of this section 377 of the IPC. It is unconstitutional. Does it make the full IPC null and void? No. Here comes the principle of severability, or principle of lapse, or the doctrine of lapse. What does it say? It says that if any part of that act which existed pre-constitution is violating the fundamental right, that only part of the act will become void. It will stay there. But once, if for example by the further constitutional amendment acts, we will reach to the point where those acts can come into existence again. So this is what it says. Then further, if we will track this case, the Delhi High Court NAS Foundation case, Delhi High Court in 2009, it claimed that it is it is unconstitutional. In 2013, Supreme Court in Kaushal case, it claimed that section 377, it is very much constitutional. As the Supreme Court, here I will write, in the Kaushal case, it claimed that section 377 of the IPC, it is very much constitutional, because this matter is dealt by the Parliament. Parliament has amended IPC various times, and they never felt a need to, amend it. So let's keep it with the Parliament. If they will ever think they need to amend it, then it would be amended. And to this, the Supreme Court was told, sir, this section can be misused, and the Supreme Court replied that it is the it is the problem of the police. They have to check on it, not the problem of the courts. So this is what was given in 2013. In 2018, another case came in 2018, which is called as Navtej Johar case, and there was again question on the section 377. And this was read down because of the because in the Kaushal case, we understood that it was given the status. It was said that it is not violating the constitution. It is very much in line with the constitution, and the Parliament should make laws with respect to it if they want to change it. And similarly, this case went to the higher bench in the Navtej Johar case. This was challenged, and what did the Supreme Court did? It read it down. Only the homosexuality, according to the Supreme Court, the homosexuality part, it is discriminatory, and it was read down. Rest was kept there. For example, bestiality, not the whole section was read down. Only this part of the homosexuality was read down. Rest, the bestiality, it is still a crime, and incest, it was still a crime. But finally, we saw that how IPC was replaced by BNS, and there is no such provision in the BNS with respect to it. So this is what the Article 13, Clause 1 talks about. It talks about if any law which is pre-independent is against is violating the fundamental right, that part of the law will be null and void. So this is what Article 13.1 says. Now let's move to the Article 13 Clause 2. We'll try to discuss that. What does that say? Now the question was, can the Parliament question was can the Parliament make laws which will be abridging the fundamental rights? This was the question. Can Parliament make laws which will abridge the fundamental right? Can executive make laws that will abridge the fundamental right. This was the question, and to this, it gave the scope of the judicial review, that if, for example, if tomorrow parliament is going to make any law, and who will see that, who will say that it is abridging the fundamental right, who has this authority, who will review the law? It is the judiciary who will review the law. And this article 13 subclause 2, it gave the scope for the judicial review. Here judicial review is not mentioned. In fact, it is not mentioned in the constitution, but we can track it here also, that from this article we can find that it gave the scope for the judicial review, as it says, state shall not make any law which takes away or abridges fundamental right. As a term, as I told you, judicial review is not mentioned in the constitution itself. We can declare that who can declare this law made by the parliament void? It is the judiciary who can do it. So this is what article 13 clause 2 says. Then we have the article 13 clause 3. What does article 13 clause 3 says? It describes the law. What is the law? Law includes any ordinance, order, bylaw, regulation, notification, customs, or usage. It describes the law, and it has there was no mention of the Constitutional Amendment Act. So now there was a question: can the fundamental rights be abridged? Can they be amended by the help of the Constitutional Amendment Act? It was a question, as this question was discussed in the 1951 in the Champak case. When the Madras government issued an order about the reservation of seats for the SCs and STs in the government medical and engineering colleges. And when they were asked, and when the Madras government was asked why did they do so, they said that look at the article 46, where we are supposed to uplift these costs. We are supposed to uplift the scheduled tribes and scheduled costs. But the Supreme Court said that article 46, it comes under the DPSPs, and we know that DPSPs are inferior. They are inferior to fundamental rights. So by this they made it, what they did, they said that this is very much unconstitutional, and it was struck down. Because of this amendment, the government came up with the article 15.4, which we will discuss when we will discuss article 15. Then finally there came the term of the Golaknath case, where SC said by using article 368, there was a discussion: can we abridge or amend the article, amend the constitution or amend the fundamental rights by using article 368 or by Constitutional Amendment Act? The answer to it was that you cannot do it. But then came the 24th Constitutional Amendment Act, where it was introduced. Article 13 subclause 4 was introduced, where it was mentioned that by using this Constitutional Amendment Act, you can abridge the constitution or amend the constitution. But one thing you have to be very much clear of: what is that thing? That you are not violating, or you are not touching the basic structure of the constitution. You are not touching the basic structure of the constitution. So this is what we discussed under article 12 and under article 13. With this, I hope you had understood article 13. You had discussed what are its various clauses. How in clause 1 it says that if any law which is pre-independent, that is against the fundamental rights, then that law will become void. Will the whole law become void, or that particular provision or that particular phrase? It says that particular phrase will become void. Second, we saw that how second we saw that how the government cannot abridge the fundamental rights by the ordinary laws or by simple laws. They cannot abridge it. Who will see that the government has violated the fundamental rights? It is what? It is the judiciary. It gave the scope for the judicial review. Then we saw that what are these laws which the government cannot do? It is defined under article 13.3. And finally there was discussion: can by using article 368 can we amend the fundamental rights? And finally, by 24th Constitutional Amendment Act, it was introduced that article 13.4 was introduced, which highlighted that you can amend the fundamental rights by using the Constitutional Amendment Act, but you have to keep care of the basic structure of the constitution. You cannot touch that. So this is what it is about. This is, this is what we discussed yesterday. And in fact, let me repeat again, you need know, if you are watching this lecture, then think that we had started the fundamental rights from today itself. Now let's move to the article 14. Before we will move to article 14, let me rub the board here, and then we will do the proper discussion over it. Before we will solve the article 14, we will shift to the question which we discussed yesterday also. Let me repeat the question again today, so that it will clear your confusion if there is any. Let's try to solve the question on article 13 today. Here the question says, which of the following statements about Article 13 of the Indian Constitution are correct? First statement, Article 13 serves as a bulwark for fundamental rights by mandating that all laws inconsistent with it or in derogation of these rights shall be void. 100% correct, that we discussed. The term law as defined in Article 3 explicitly includes statutory enactments, ordinances, bylaws, rules, regulations, customs or usages having the force of law. Correct. Third, the doctrine of eclipse applicable to pre-constitutional laws inconsistent with the fundamental rights implies that such laws are not rendered dead but merely become inoperative until the inconsistency is removed. 100% correct. Fourth statement, the Supreme Court is in its landmark Keshwananda Bharti case definitely ruled that the constitutional amendments are not a law within the meaning of the Article 13 and are therefore entirely beyond judicial review even if they abridge fundamental rights. This is totally incorrect. So with respect to this question, the correct statement was statement 1, statement 2 and statement 3, and the correct option would be option B. With this, let's move to the first, let's go back to the first slide and discuss Article 14. So today's discussion, the new discussion which we are going to make, I don't want to confuse you if you are watching this first time. Believe you don't need to go for the fundamental rights to our earlier lecture, because we had just repeated everything what we discussed there. But for other concepts like citizenship or the other concepts which we discussed in our yesterday's lecture, you need to watch that. So here today we will discuss Article 14. So what is this Article 14? What does it say? As we discussed the different rights given to us, and one of the rights which is defined by the fundamental rights is the right to equality. So what is this equality that we will understand? We will try to understand through this Article 14. As Article 14 states, it states that the state shall not deny. What does it state? Let me repeat it here. Let me write it here. It states that the state shall not deny any person, equality before the law, The state shall not deny to any person equality before the law or the equal protection of the law or the equal protection of the law. So what does the article say? The state shall not deny to any person equality before the law or the equal protection of the law. If you will analyze this article, you will find out one very important thing in this article. This article, whom it is referring to? It is referring to any person. What does it mean? That it includes both citizens as well as aliens. So it is for everybody in the country. The state shall not deny to any person equality before the law or the equal protection of the law. So it limits the state. State cannot deny equality before law and equal protection of the law. So let's define what is this equality before the law. What is this equality before the law? Let's try to understand that. What is this equality before the law? For example, I will give you an example here. Suppose I am a person. You would have seen this. This photograph where there are three persons. There is a barrier to them. They are trying to watch the match. One is taller. Another person, he is of medium height. and the another person is of the less medium height, or the shorter person. So you would have you would have seen this picture, on the social media. So what is this equality before the law? What is this equality before the law? So is it that everybody should be treated equal? If equality is given here, is it that the same equality should be enjoyed by this person? The state should not interfere in here. Is it that the state should not interfere in here? Or what state should do? State should come up, they should give some assistance to these people, take away something from him, so that all the three will enjoy, this match. All the three will be in a line. All the three would be in line. So this is the concept of equality. Which we follow in our country. Equality is not absolute. Before discussing the equality before the law, equality is not itself absolute. You cannot treat everybody equally. For example, there are two persons. For example, if anybody attacks me, if anybody robs me, you cannot treat me and that person equal, because I had been, I was, attacked by him. I am the one who is the victim and he is the one who is the oppressor. So equality is not absolute term. Now, before going to the further discussion into it, then we will reach to the equal protection of the law. Here we need to discuss what is equality before the law. Here what we need to discuss is what equality before the law is. Here we need to discuss what equality before the law is. Equality before law. You would have heard one term, that is the rule of the law. That is rule of the law. That everybody is equal in the eyes of law. So what is this rule of law? First, let's try to understand what is this rule of law. Then we will connect it with the equality before the law. You will understand the concept. Then we will move forward. This equality, this rule of law, no person shall be made to suffer. There are three criteria. To understand the rule of the law, you will have to ask A.V. Dicey about what this concept of rule of law is. A.V. Dicey will tell you that there are three criteria to understand the rule of law. What are these three criteria? First one, what is it? No person shall be made to suffer in body or goods except for a breach of law. For example, what does it says? Suppose you are living in 17th century. You are living in 17th century, and you are dark in color. So what the law will do you during that time? If you are dark in color, there is no law, there is no rule of law. You would be taken, you would be taken illegally, and you would be made the slave, You would be made slave. You would be given the body harm that you will have to work for certain hours, and you will be not paid for that. Even if you would have done nothing. You were just minding your business. So person came in, he took you up and told you to work for him, and he is not going to pay you. So this is the slavery. This thing, it is not protected. There is no rule of the law. It is very much unfortunate. You had not violated the law, you had not breached the law, but still you are being given, you are suffering. Why? Because your body color was black, or there was some other deficiencies in you. That is what the first criteria is about the rule of law, that no person shall be made to suffer in body or goods except for a breach of law. Now what the rule of law says right now, even if you are black, even if you belong to any caste, even if you belong to any religion, if you had done nothing wrong, you will not be taken by the police or by any authority. You cannot be taken by any government authority or police or any authority at all, because this is what the rule of law says, unless you had breached any law. For example, now there is a question. Suppose there is a black man in our country, and he was involved in theft. He was involved in theft. Can he be taken to the court? 100% he can be taken to the court. He can be taken to the jail. Is it the breach of rule of law? No, it is not the breach of rule of law. Even though he is black, even though he belongs to any particular religion, even though he belongs to any caste, but he has done the crime. He has done the theft, and because of this theft, because of this thing which is against the law, he is being taken to the court, not because he belongs to any religion. So this is the first criteria of a state being following the rule of law. They have to follow that, that if anything, you cannot you cannot make suffer anybody, no person shall be made to suffer in body or goods unless you had breached the law. This is the first criteria, that it follows the rule of law. Now second criteria, what is that? Anybody can sue you and you can sue anybody. Anybody can sue you and you can sue anybody. Mr. A.V. Dicey says another concept, another criteria that the rule of law is followed in a state is that if there is any person, you can go in the court against that person, and that person will also have the right to go in the court against you. So there is this equality. So this equality, the rule of law, when it has this feature, when these features are, we say that there is a rule of law. And this is exactly what becomes, this is exactly how we came to know that, if any state there are these features, then we exactly can say that there is equality before the law. There is equality before the law. Earlier, what used to be the notion? Earlier notion was king is the law. King is the law. Whatever he says, that is the law. Now the notion is law is the king. Law is the supreme. Law is the supreme. Whoever you are, you can be the Brahman, you can be Dalit. If you had done any crime, both would be seen equally, irrespective of your status. But irrespective of your status, irrespective of your irrespective of to what caste you belong, irrespective of your religion, if you both have done the same crime, the punishment would be same, the forgiveness would be same, irrespective of your status. That is what the rule of law says. That's what exactly the equality before the law says. But this equality before the law, this article 14, it is not absolute. There are some exceptions to it. Now let's try to understand what are those exceptions. There are some necessary exceptions which are required, and let's analyze them. Let's try to understand them. What are those exceptions? The first exception, for example, now you are a president. You are a president or governor of a state. If there is, and you are in the office, it is your term, and you had made any official statement, or in your personal life you had done any act, you cannot be taken to the court. There is a protection to you. You cannot be taken to the court if you are the president, if you are the governor of any state, and you had done any action, you had done anything, then you cannot be taken to the court. Why you cannot be taken to the court? Because there is a protection to you. There is protection to you during the span of time you are in the office. During the time of the office, majorly 5 years, you cannot be taken to the court. Even if you are accused of a murder, even if you are accused of a murder, you are accused of the molestation, you are accused of the rape, still the case cannot be filed against you. But once you leave the office, the investigation may start against you. So this is what the exception is here. And also the another exception is given to the, first it is given to the president and governors. Another exception which is given to the whom? It is given to the visiting heads and foreign diplomats and it is given to the visiting heads of the states, other state of the foreign states, and their foreign diplomats. They cannot also be sued in the courts. They cannot also be sued in the courts. If there is any accusation against them, the maximum a country can go do, the maximum a country can do, they can issue the, they can issue the persona non grata. Maximum they can do, they can issue the persona non grata, that that person who is accused has to leave within what, within 24 hours. Recently this persona non grata, we saw it with respect to Canada, when there was diplomatic tussle between India and Canada, and India issued this persona non grata for Canadian diplomats who were in India. So this is given to them. Why it came, why this protection is to the visiting heads or the foreign diplomats? It is because of the Vienna Convention. Because of the Vienna Convention, this on diplomatic of relations. Because of the Vienna Convention, this was adopted. Because of the Vienna Convention, this was adopted, that the diplomats will be given absolute immunity in which country they are serving. Because it was during that time in 1961 this was framed, Vienna Convention, because it was a time of the Cold War, and people, countries USA and USSR, they were having the allies. And if any country who is not the ally of USA, if their leader or diplomats were in those countries who were the allies of US or USSR, they would prosecute them, they will kill them. So to stop this, this Vienna Convention was reached, and this immunity was given to them. So this is the equality before the law. Let me recap it in the simpler terms so that you will understand it much better. Equality before the law says, irrespective of your status, whether whatever you are, you may be Brahman, you may be anybody, if you had done any harm, if you had violated the law, then you are punishable by the law equally, whether you would be Brahman or anybody, whether you would be Muslim or you would be Hindu, whether to whatever religion you belong to, you would be seen very much equal before the law. But there we saw that there are exceptions, and this notion of equality before the law, it is being inspired from what? It is being inspired from the rule of law. And the Dicey, the A.V. Dicey, he defines the criteria of rule of law. What are the criteria of the rule of law? We discussed that no person shall be made to suffer in body or good except for a breach of law. And another was anybody can sue or be sued. Then the third one, which I did not mention deliberately because it is much specific to UK. Constitution is the result of the ordinary law of the land, but in our country it is the result of the when the Constitution Assembly came in, ours is the written constitution. So that is not the point which we want to discuss here. But here I suppose you had understood the this connotation, equality before the law, how it is inspired from the rule of law, and by A.V. Dicey's definition, how it comes in, how we are able to understand the equality before the law. Now another term, now I hope you had understood the equality before the law. Now let's try to understand another term which is mentioned in the same article, Article 14, which is first equality before the law, then the second term which is equal protection of the law. Now let's try to understand what this equal protection of the law is. Let's try to analyze it. This Article 14, this gives the scope, this part of the Article 14, which is equal protection of the law. It gives scope. It gives scope to reservation. When I try to define the equality, I showed you that the example of the picture, which you would have often seen. There are three people who are trying to watch the match. One is of good height, another one is of normal height, and the third one is very short, and there is a barricade. And because of this, the taller one, he is able to watch the match. These two, he struggles to watch the match, and he cannot watch a single ball. So what is the equal protection of the law here? What does the equal protection of the law, this notation says? It says that in simpler terms, it says this is equality. It basically talks about equity or justice, we can say. When equality is added with justice, it becomes equity. What does it say? That it says that take something away from this. For example, he was sitting on two step ladders. So it says that take something away from him, add something to him, and adds something to him also, so that all the three would be equal and they can enjoy the match equally. So it talks about this notation of equal protection of the law. It talks about what? It talks about the equity, that it says that not everybody is equal. And I already told you that about the equality, there is, no one is equal. We cannot say everybody is equal. There are differences. We cannot believe that everybody is equal. This is very absolute statement, very, and this equality, it is not absolute, it is not, and if we try to bring in the equality in the society, then it will have a very worse impact. It will have very worse impact. So it is better to go for the equity than equality. So this is the equal protection of the law. What does it say? It says basically is talking about the equity. And where from we got this notion of equal protection of the law? We got it from the US Constitution. And equality before the law, we got it from the Britain Constitution. And also in this, I described you that how like should be treated alike, how it is done, equality in the equal protection of the law, how states interfere in here. States, they can tax. If anybody is having more money, earning more money, more than 10 lakh, they are taxed in one way. And if there are people, they are taxed in different way. Can the richer people go to the court? Sir, there is no equality. No, they cannot go to the court, because the aim of this notation, equal protection of the law, is to bring equity in the society, and it is how it is done. This equity is done. And also one more thing which you need to understand here. One more thing which you need to understand here is the notation that equals should be treated equally. As we saw this case, for example, there was a case in a stadium. So they did this. Can they leave it here? And if there is any such case again, for example, there are many such cases in the stadium, can they only do it for the one? No, they cannot do it for the one example only. They have to do it for everyone. They have to bring equity for the everyone. Then this is the equal protection of the law. So with respect to this, there is an example. We can, if we want to understand it legally now, let's take the example of the adultery. Let's try to understand. Let's take the example of the adultery. Then we will try to understand it, how the equal protection of the law works, how it is different. Let's take the example of the adultery. You would have heard about adultery. I believe so. What is the adultery? Suppose there is a man, and there is his wife, husband. Here is husband and wife. They are in a relationship, and there is outsider, and these two are in a relationship. What? They are in a relationship. So he goes to the court. He says that, sir, my wife and the outsider are in a sexual relationship. They are involved in adultery. What does the court do? Court will punish him, because court will believe that this woman, she would be seduced by him. She is the victim, and this outsider, he is the criminal here. He would be punished. So he would be arrested. And the principle which was used here, that which was used, that the wife is the property of the husband, and it was stolen by the outsider. It was stolen by the outsider. That is the principle which was used. Then came the case. This case went to the, because if you will read the case itself, if you would read the adultery itself, it is very much derogatory. towards the woman. It is very much it restricts the rights of the woman. It makes them the property of the husband. So there were many loopholes to it. So the case went to the Supreme Court under the Joseph Joseph case of 2018, Joseph Stein case of 2018. So there were two judges hearing it. What the first judge said, that the concept of adultery is unconstitutional. It is discriminating against man. According to first judge, it is very much unconstitutional. The concept of adultery, it is itself unconstitutional because it is discriminating against the man. Here we are punishing the man only, we are not punishing the woman. We are believing that woman is the victim, so it is in a way discriminating the man. Second judge, Mr. Chandrachud, who was the former CJI of India, he said that, what he said that if a woman is married, he said that if a woman is married, it does not take her autonomy of sex, or we can say it does not take her, it does not lose, she does not lose sexual autonomy. The Chandrachud CJI says, the Justice Chandrachud says, if a woman is married, she does not lose her sexual autonomy. She is allowed, she can be, she can have a sexual relationship with whatever man she wants to. This can be the reason for the divorce, but it is not a crime. So because of these, because of this judgment, what was said, that the adultery was made, it was made uncriminal. Adultery as a crime for the, it was made uncriminal, that it is not a crime. Adultery cannot be the crime. It can be the reason for the divorce, but cannot be the crime. So because of this judgment 2018, then came the question, then came the question to the judiciary. They said that, sir, now we agree that adultery is not the crime. It can be the reason for the, it can be the reason for what? It can be the reason for the divorce. But sir, please make some exceptions in it. And what was the exception made? Exception was made with respect to the armed forces. And the argument is that, sir, armed force, they had left to whom? They are serving the nation. Serving the nation. And if they would be worried about their wives, what they are doing, are they in any relationship, they cannot serve the nation properly. They will be mentally distorted. They would not be mentally there. So it would be very torturous for them, because they are outside the home for months. So for them, the Supreme Court said that adultery cannot be the crime, but except for those, except for whom? Except for the members of the armed forces. Except for the members of the armed forces. If the member of the armed forces, for example, wife of the armed force, she is involved in a sexual relationship with any other person, that person will be held accountable. He will be punished. So under this, this exception was given to the armed forces. So is it violating article 14? Because article 14 says there should be equal protection. If we will read the terms of article 14, it says that the state shall not deny to any person equality before the law or the equal protection of the law. But here we can see the equality before the law, it is different. For the armed forces, if their wives are involved in such acts or their spouses are involved in such acts, then it would be called what? Adultery. But for others, it is not called adultery. Is it the violation of the act? No, it is not the violation of the act, because the second term, which is equality before the law, which is the equal protection of the law, the equal protection of the law, it gives scope to it. Equal protection of the law gives scope to it. It gives scope to it. It is not against the equality. It is not violating article 14 itself. So this was the case of the adultery. I hope you had understood it. You had understood the equal protection of the law. Now similarly, there are cases, with respect to, if we will see, with respect to women, there are anti-dowry there are various laws which favor women, which are biased towards women. For example, laws related to alimony, laws related to rape, laws related to dowry. domestic violence. So there are various laws which are favoring women. So does it, is it against this, if we will see the, if we will bring our discussion back, is it against the article 14 equal protection of law? Is it equality before the law? Is it against that? No, it is not against that, because we see that if we will see husband and wife, who demands the dowry? It is the husband who demands the dowry. Who is getting raped? It is the woman who is getting the raped. Who is physically more stronger? It is the husband who is physically more stronger. So definitely if there is violence, it is against a woman. So there is definitely the need for the protection for the woman. So they are protected under this equal protection of they are protected under this notion that equal protection of the law, equal protection of the laws, that you can treat like alike, but you can give the reservation in here. You can protect different sections of the society under article 14. So this is what article 14 says. I hope till now you had understood it. It has basically two notions on which the discussion was very much necessary. The first notion was equality before the law. How we can reach to equality before the law? For that we have to understand the rule of the law. For that we need to consult Dicey, A.V. Dicey. He describes the rule of the law, how it can be achieved. For example, he says that there are three criteria to say that in a state there is a rule of law. What is the first criteria? No person shall be made to suffer in body or grounds except for a breach of law. Second, anybody can sue you, or you can be sued. You cannot arrest arbitrarily anyone. So these were the criteria. And then we discussed with respect to equal protection law, what are the exceptions to it. We discussed the case of the president and the governor, and also we discussed the case of the visiting heads of foreign states and the foreign diplomats. They are not also answerable to the courts. The maximum the country can do, they can issue the persona non grata, where they will have to leave the country within 24 hours, otherwise they will get arrested. Then we discussed our second notion, which is equal protection of the law. It is borrowed from US. We discussed that how it is basically focusing on equity rather than equality. Equal protection of law becomes equal protection of the law when justice and equality is added. When justice and equality is added. So this is how we reached to it. We saw various cases where, for example, in adultery, where there was discrimination towards men, where where there are, when it was made unconstitutional, but still it continues for the armed forces. So this exception is made for the armed forces. Then similarly there are various laws which are favoring women with respect to dowry, with respect to rape, with respect to domestic violence, but they are very much in constitution, because there is a need to protect them, because men and women are not biologically equal. So there was definitely the need for that. And if we will see the history, how women were treated from the history, so definitely there is the need for that. So this is what article 14 says. Now let's try to solve a question on this and try to find out what question can be formed on article 14. Here the question says, with reference to article 14 of the Indian Constitution, consider the following statements. First statement, it embodies the principle of equality before the law. 100% correct, which is positive concept borrowed from the American Constitution. Is equality before the law borrowed from the American Constitution, or equal protection of the law is borrowed from the American Constitution? Equality before the law, it is borrowed from the UK Constitution, and equal protection of the law is borrowed from the American Constitution. So first statement becomes incorrect. Now we can directly eliminate option A and option D. We are left with 2 and 3. What is second statement? It says it allows for the reasonable classification of persons, provided the classification is based on the intelligible differentia and has a rational nexus with the objective of the law. Correct. Third, the president and the governors enjoy absolute immunity from all civil and criminal proceedings during their term of office, which is an exception to article 14. Correct. So with respect to this question, the correct statement is option C. With this, I hope you had understood article 14 also. Now let's shift back to the first slide and try to discuss article 15. Then we will conclude it. Here, let me rub it first, and then we will discuss article 15. Let me rub it first. discuss Article 15. There are various sub clauses of Article 15 which we would have to discuss. So what does Article 15 do? Article 15 says it says the state shall not discriminate. Article 15 says the state shall not discriminate any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them, So let's try to analyze the article itself. It says the Article 15 clause 1 says state shall not discriminate any citizen. That state shall not discriminate any citizen. So this article, it is focusing on whom? It is focusing on citizens specially. So this article is focusing on citizens specially. And what are the grounds on which the state cannot discriminate? State cannot discriminate on religion, state cannot discriminate on race, state cannot discriminate on caste, state cannot discriminate on sex, state cannot discriminate on the basis of the place of birth or any of them. Can state discriminate on the basis of age? Yes, it can discriminate because it is not mentioned in the article. Suppose how it can discriminate. Suppose there is a government college, you want to enter into the college and you are just 5 years old. Can you enter into the college? No, state will say no, you can't enter the college. So state can discriminate on this. Can state discriminate on the basis of merit? 100%. They will hold the exam and you are not clearing it or you are not appearing into the exam. So on these basis, even though you are Dalit, even though you belong to particular religion, even though you belong to particular caste, you belong to particular race, you belong to particular place of birth, you cannot be discriminated. So even though if you belong to these, still you can be discriminated if not on these basis, but if you are not following the merit, if you are not in the age group what is required, if if other criterias are not in line. So this is what Article 15 basically 15A basically 15.1 basically talks about. State cannot discriminate on these on these terms like state cannot discriminate any citizen on the grounds of religion, race, caste, sex, place of birth or any of the above. Now can I discriminate you on this basis? For example, can I discriminate you that I will not teach you here? I will not, if you belong to any religion or any of the race or any of the caste, okay, or any of the caste, can I discriminate you? 100% under this act you can discriminate. But this act, Article 15.1, it is specific to whom? It is this is specific to. It is specific to the state. It is specific to the state, not to the person, not to the private person. So this act, Article 15.1, it is clause 1, it is specific to the state. So 100% a person under this Article 15.1a can discriminate. Then the second clause of it. First clause says state shall not discriminate any citizen on grounds only of religion, race, caste, sex and place of birth or any of the above. This is specific to the state, not to the private person. If this discrimination is done by the private person, then you cannot go to the court, sir, this he is violating Article 15 here. You can file different cases and that we will discuss. But with respect to this Article 15 subclause 1, you cannot take me to the court. Now what is this Article 15 subclause 2? Let's try to discuss that. Article 15 subclause 2, what does it say? It says that no citizen shall be discriminated entering into the shops, public restaurants, hostels, place of public entertainment, for example cinemas, or use the tubs or bathing gods. You cannot be discriminated on that. For example, now let me give a example. Suppose you are drunk and you want to go to library, can you discriminate it? Can you be stopped? 100% you can be stopped. Why? Not because you belong to any of these particular religion or any of the particular race or any of the particular caste. You are stopped to enter into the library because you are drunk. If you will enter into the library, in a library there is a decorum which you have to follow. You should keep quiet, and when you are drunk you will make noises there. You will disturb the discipline there, so you can be thrown out. Similarly in cinemas, if you are drunk, you can be thrown out. If you do an indiscipline, you start smoking in the cinema hall, because of smoking in the cinema hall you can be thrown out. But on these basis, this discrimination cannot be done. Or you are in the swimming pool and you start peeing in the swimming pool, you can be taken out of the swimming pool because of that, not because of any religion. So this is because of any of these criteria given in article 15 clause 1, not because of these but because of the activities which you are doing there. So this is what article 15.2 says. You cannot be discriminated in accessing shops, in accessing cinema halls, in accessing public restaurants, or accessing the bathing ghats. If you belong to these particular if you belong to these particular criteria as given in article 15.1a. But one thing is very much necessary, that public resort or which are all these stuff, which is, for example, bathing ghats, roads and places of public resort, which are maintained wholly or partially out of state funds, or dedicated to one of use of the general public, or which is dedicated to the use of the general public. Similarly, this is article 15.2. Now what is article 15.3? Let me rub it. I hope it is clear. Article 15.1 is clear that you cannot be discriminated on the basis of religion, race, caste, sex, place of birth, or any of them. But we discussed the example that you have not cleared the merit, you can be discriminated, you can be denied the admission, but not on this basis. You would have seen the example of the IITN student who belonged to the Dalit community, and he was little late in paying the fee, and he was not given admission. But he went to the court, not because of this he was denied the admission because he belonged to the Dalit community. He was not given admission because he did not pay the fee on the time. He went to the court, and Supreme Court used article 142, and under this the complete justice was given to him and he was allowed to pay the fees. So that is something different. We discussed article 15.2 that no citizen shall be discriminated in entering the shops, public restaurants, hotels and places of public entertainment, the use of wells, tanks, bathing ghats, roads and places of public resort maintained wholly or partially out of the state funds, or dedicated to the use of the general public. Or dedicated, there is a term which I want to explain on. Dedicated to the use of general public. So this is the term on which I want to add few points here. Suppose I have private property, and you belong to any religious group, or you belong to any caste, and I will not let you in my private property. Am I violating article 15? No, I am not violating article 15. But suppose what I am doing, I am converting this private property into a public park, and now I will write on the board that particular community is not allowed in this park. Is it violating the article 15.2? 100%. Then I will violate the article 15.2. If it is for dedicated to the use of the general public, then I cannot discriminate. If it is my personal property, I can allow my friends, I cannot allow all the people. I can allow people of the particular community, I may not allow the people of all the communities. That is something different. So that is the point which I want to highlight here. Now coming to the third, which is article 15 clause 3. What does it say? It says nothing in the article shall prevent the state from making any special provisions for women and children. What does it says? It says nothing in this article, shall prevent the state from making special provisions for women and children. We saw that you cannot discriminate on the basis of religion, race, caste, sex, place of birth, or any of the above. Now you wanted to, we are seeing that, because of this, there is reservation for the woman in their, representation of women in the parliament, in the parliament and the state legislatures. You want to do anything, as it is said that if you want to do anything good to the woman, you want to do anything good for the children, you can do it under Article 15. You can do anything under Article 15. Then after, this is about women and children. Anything you want to do for the women and children, you can do under Article 15. Then let's talk about SCs and STs. We discussed the case of the Madras government when they tried to give reservation in government engineering and medical colleges for SCs and STs, how it was challenged by the Champak Dorajan case versus the state of Madras, and how this thing was made unconstitutional. But after this, what happened? After this, what happened? The a constitution was amended and Article 15, Clause 4 was added, and under this clause, it was done by the first amendment of the Constitution, first Constitutional Amendment Act. It was done. This clause was added, Article 15(4), and what was added, that state under this, it was added that state can make special provisions for the advancement of any socially and economically backward classes of citizens, or for the SCs and STs. If there is any socially or economically backward class of citizens, or especially for SCs or STs, you can make any reservation for them under this article, which is Article 15, Clause 4. So this was for the SCs and STs. Now there was the demand whether it is only for the government aided colleges only. Is it kept with, is it this for example the Madras case we discussed, where it was for the government colleges or government aided colleges. Then for that, the another amendment act came in, which is Article 15, Clause 5, through the 93rd Constitutional Amendment Act. It was introduced that in all educational institutes except the minority educational institutes, except there is exception, which is minority educational institutes, whether it is private or not, in all educational institutes this reservation should be given to SCs and STs, except where, except minority educational institutes. This is Article 15, Clause 5. It was introduced through what? Through 93rd Constitutional Amendment Act. Now because of these, the reservations are given in the educational institutes. If there is 15% reservation for SCs, 7.5% reservation for STs, and 27% for OBCs. Now what does the Article 15 Clause 6 say? Let's try to discuss that, and we will conclude Article 15 here. Let's try to understand Article Clause 15 6. Let's try to understand what does it say. Article 15 Clause 6 says, 10% reservation to economically weaker sections. For the economically weaker sections, you can do reservation for them, and it was introduced by the 103rd Constitutional Amendment Act in 2018. So this was introduced, and you can give 10% reservation to economically weaker sections. So now let's try to add up what is the reservation criteria. For SC it is 15%, for ST it is 7.5%, for OBC it is 27%, other backward classes, and for economically weaker sections it is 10%. So this much reservation is given, and it is being protected by Article 15. In nutshell, this is what Article 15 is about. In basically Article 15, let me recap it now. Let me rub it and let me recap the Article 15 for you guys. Then we will shift to the question. Let me recap it in the simplest terms so that you will remember the facts here, and it will help you in clearing the exams. The motive of the Article 15 is that you can do anything. The reservation is allowed. Reservation is supported by, in educational institutes, is supported by Article 15. You want to do anything great for the woman, do it under Article 15. You want to do anything great for the children, do it under Article 15. So Article 15, what does it say? It says that state shall not discriminate any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them. You know, you want to seek the admission in any college and you belong to any caste, any religion, you cannot be denied the admission. But there can be another other factors too. For example, you are not getting the merit, then you can be denied. So this is Article 15.1. What does Article 15.2 say? Article 15.2 says no citizen shall be discriminated in entering the shops, public restaurants, hotels, place of public entertainment, the use of the well, tanks, bathing tubs, roads, and place of public resort maintained wholly or partially out of the state funds or dedicated to the use of the general public, then you cannot be discriminated. And about the Article 15.1a, it is targeting what? Who cannot discriminate? The state. If there is discrimination from the private person, you cannot go to the court here also. Then the third here, Article 15.3, what does it say? It says nothing in the article shall prevent the state from making any special provisions for women and children. Whatever you want to make for the women and children, do it under Article 15.3. So it protects the rights, it uplifts the women and children. Similarly, we have the Article 15.4. Article 15.4, it was added by the first Constitutional Amendment Act, and state can make special provisions under it. The state can make special provisions for the advancement of any socially and educationally backward classes of citizens, or for the SCs and STs. Reservation in government institutes, demand, what about now? There was a demand for the private institutes, and for that there came the Article 15.5. What does it say? It was introduced through the 93rd Constitutional Amendment Act in 2005. What does it say? It says in all educational institutes except minority educational institutes. So there should be this, this reservation should be given in all educational institutes except minority. Whether they are funded by the private or they are totally private, this should be given. But if they are minority institutes, then this is not applicable to them. Then what about the socially and educational backward classes? What about the economically weaker sections? For them, the Article 15.6 came in, and this was brought in by the Constitutional Amendment Act of 103rd Constitutional Amendment Act in 2018. It was brought in that if you belong to economically weaker sections, then 10% reservation is for you guys. So this is about the Article 15. I hope you had understood it. Now let's try to solve the question here, and then we will conclude our discussion. Here the question says, with reference to the Article 15 of the Indian Constitution, consider the following statement. First statement, it prohibits the state from discriminating against any citizen solely on grounds of religion, race, caste, sex, or place of birth. Correct. The state is empowered to make special provisions for the advancement of socially and economically backward classes of citizens, including reservation in private unaided educational institutes. 100% correct. The provisions for special measures for economically weaker sections of citizens were introduced through a constitutional amendment. 100%, 103rd. So with respect to this question, all the three statements are correct. Now with this, we complete our today's discussion. I hope I was able to make you understand the fundamental rights and these articles, Article 14, 12, 13, 14, and 15. Now tomorrow, what we are going to discuss, we are going to discuss Article 16, which may take some time, then 17 and 18. These articles which we are going to discuss tomorrow. So with this, let me finish the class here. Thank you for staying with me. Thank you very much, and have a nice day.